For many, many years, Judge McManus had a theory that everyone should spend 1 day drunk and 1 day sober. So everybody that got convicted of drinking driving spent at least 2 days in jail.
What happens when someone is caught driving drunk but has no criminal record, no accident, and cooperates fully with police? In this courtroom, Michael Kennedy admitted to impaired driving after being stopped for speeding with a blood alcohol level just over the legal limit. The judge said this case was at the very bottom of the scale. But here's the real question: should someone still face jail for drunk driving when nothing terrible actually happened?
This is an interesting case. They come in all shapes and sizes. This is Cole Michael Kindig. The file is 252335. As far as I can tell, Mr. Kindig has no previous criminal record. At any rate, the defendant is here with his lawyer, Mr. Tim George. This pre-sentence report was prepared by Daniel Frazine, who is on vacation. So he's not here, but he did prepare his report. Mr. George, what would you like me to know?
Thank you, Your Honor. I think it goes without saying in these types of cases, obviously, there's always an inherent danger whenever an individual makes the decision not only to drink or use controlled substances, but then get behind the wheel. And my client understands he's fortunate that he didn't hurt or injure or kill himself or somebody else. Just as an update in the report, he did report to me that he is a pipe fitter with Local 357.
Yes.
Sounds like he works different jobs, different hours. So he does have that type of employment going from him. As the court did indicate, he doesn't have any type of prior criminal history. He was pulled over for speeding in this matter. All reports that I have is that he was cooperative with the police and in the investigation. I think the time that he did spend in custody was an eye-opener for him. My client is young, and I think that in reviewing the report, he does realize that he was living a lifestyle that probably wasn't conducive to great choices. At the same time, Your Honor, he did plead to an impaired driving in this case. There's a relatively above the legal limit but low blood alcohol content. There was not an accident. We would ask the court to consider whether fines and costs and time already served would be appropriate. In the alternative, if the court did feel that a supervised probation was appropriate, we'd ask the court to impose a 6-month probation that would allow him to get the Prime for Life, the victim impact panel, and some testing done. I believe that can be accomplished in 6 months rather than 12. Thank you.
Ms. Geschwint, this is a White Pigeon case, and we get quite a few of these. White Pigeon is at the intersection of US 12 and US 131. So there are 2 highways that go through there, and we get our share of cases. This one was going down US 12. But my recall, you were coming from Sturgis?
I was coming from Elkhart.
Elkhart. All right, Ms. Geschwint, what's the village's perspective on this?
And the village believes that a period of probation would be appropriate. I do agree with Attorney George that maybe 6 months is more appropriate than 12. As previously indicated, the BAC was rather low. There was no prior criminal history, no accident, but I do believe a period of probation would be appropriate in this matter, just to make sure that at such a young age, he does not start down a bad path, keep him on the good path.
I'm certainly in favor of that. We do something called a timeout probation, where we give people a timeout from alcohol. We've become somewhat desensitized to high blood alcohol levels. The next case we have was very high blood alcohol. Lady driving down 131 at a 247 in the middle of the afternoon. We've been seeing 3s. Someone the other day was a 5.7, not driving, but she was taken to the hospital. The Auburn Hills case from 2023 says that district courts are supposed to sentence their defendants proportionally. And they didn't explain what that meant. Circuit court has a requirement of proportional sentencing, and they have the sentencing guidelines.
Under Michigan law, impaired driving is still a criminal offense even if there's no crash. The judge explained that courts must sentence people proportionally, meaning the punishment should match the seriousness of the case. Kennedy had no prior record and a relatively low blood alcohol level, but he still drove across multiple cities while intoxicated. So the question becomes, does the law demand punishment or just a warning?
District court does not have sentencing guidelines. We have our own that we use for drinking driving offenses. And so proportionality means, I guess, there's a spectrum of how people are to be sentenced. In addition, the Criminal Justice Reform Act implemented a presumption that there is no jail or probation in non-serious misdemeanors. And in the wisdom of the state legislature, drinking driving cases where there is no accident is a non-serious misdemeanor. So I've been thinking about this case since last week. I think I first read this on Thursday afternoon. Proportional to what? If this defendant is on the proportional scale, he's at the bottom. His blood alcohol was certainly over the legal limit. His PBT was 104, and the actual test came back at 0.96, which is over the legal limit. But at the very low end of the cases we see, but that's where the desensitized mark. I mean, you're good and drunk at 0.096, shouldn't be operating on a public roadway. You've got no traffic tickets, no criminal record whatsoever. As your lawyer indicated, you were polite and respectful to the officers. There was no bad driving. You were going 47 and a 35, which is very common right there. The only thing that troubles me is you were going all the way from Elkhart to Portage at this blood alcohol level. And as your lawyer and the prosecutor said, it's fortunate nobody else was hit, or you didn't hit something. But in terms of proportionality, you're certainly at the bottom of the scale for 2026 and at the bottom of the scale for all of last year. They did give you an impaired. An impaired is given in, I think, a high percentage of the cases. And the legislature says this is a non-serious misdemeanor. So if I got to be proportional, somebody has to be at the bottom of the proportion. The fine is $300. There's a $75 crime victims' rights fee, a $50 state minimum fee, a $100 screening fee, $150 attorney fee, police reimbursement of $120. I'm going to order you to do the victim impact panel, which is $32. Let's add all that up. You got a PR bond, so I don't have any money to apply to this. When they tell you drinking driving is expensive, they're right. You've got a good job, so you have the ability to pay this. But 300 plus 125 plus 100 plus 150 plus 120 plus 32 is $827. That's as low as it gets. Let me add this again. 300 plus 125 plus 100 screening fee plus $150 attorney fee, $120 police reimbursement, good for White Pigeon for including it, $32, $827. You are to attend the victim impact panel within 6 months. I'm not going to put you on a probation, and I'm not going to order any additional jail time. For many, many years, Judge McManus had a theory that everyone should spend 1 day drunk and 1 day sober. So everybody that got convicted of drinking, driving spent at least 2 days in jail. But you can't do that anymore. There's some logic in it. You got arrested on the 16th. Mr. Candig, you're the first person in this year that hasn't received a jail sentence as part of their sentence. And I hope what happened already is enough. A high percentage of people that get arrested for drunk driving never come back. It's expensive, it's embarrassing, it's humiliating. It's like, I don't ever want to do that again. I'm hoping that you're in that percentage. There's another percentage that come back over and over again, and they take up a lot of our time and effort.
The judge pointed out something surprising. Compared to many cases he sees some with extremely high alcohol levels, Kennedy's case was one of the lowest on the scale. No reckless driving, no injuries, and full cooperation with police. But the judge still warned him, driving at even 0.096 alcohol means you're good and drunk behind the wheel. So was this simply a mistake or the beginning of a dangerous pattern?
So hopefully this is enough to make you realize you can't try to get from Elkhart to Kalamazoo after drinking a bunch of alcohol. There's a high likelihood that an accident may have occurred. You can also do the victim impact in Kalamazoo. I'd rather you did it here. Give you an envelope regarding a fine. You can pay with a credit card. You can send in payments. Pay it all at once in green cash. But today is March 2nd. It's due by 8/2/26. All right, give you that. As I indicated, all the factors: no prior criminal record, no prior traffic record, relatively low blood alcohol level, no accident, polite, cooperative with the officers, and no significant bad driving other than speeding, all led to this. All right, you take this out to the counter and they'll give you some information about the victim impact panel when it is.
In the end, the judge made a rare decision: no jail, no probation, just $827 in fines and a victim impact panel. Kennedy even became the first person that year to avoid a jail sentence in a drunk driving case. The judge hoped the embarrassment and cost would be enough to change his behavior. But what do you think, was this fair justice, or should every drunk driving case include jail time?